31C deal with right to property. The objective of Article 31C is to prevent concentration of wealth and means of production, and to ensure the distribution of ownership and the control of the material resources of the community for the common good. Article 31C is thus essentially an extension of the principle accepted in Article 31A. Article 31A having been held to be valid during all these years, its validity. Kesavananda Kilo Ella, Kanna, J. 57A now be questioned on account of the doctrine of starchiasis. The pound which sustained the validity clause of Article 31A would equally stain the validity of the first part of Article 31C pp. 743-744. Sankari Prasad Union of India, 1952. JSCR 89 and Lumer v. Garnett, 258 U.S. 130 referred to. The second part of Article 31C contains the seed of noonal disintegration and is invalid on the grounds I. It gives a carte blanche to the Kajisal tour to make any liolative of Article 1419 and make it immune from attack by instituting TJ requisite declaration. Article 31C, taken along with its second part, gives in effect the power to the legislature, including a state legislature, to amend the Constitution in important respects, and it goes beyond the permissible limits of what constitutes amendment under Article 368, since the exclusion of even limited judicial RTVU strikes at the basic structure of the Constitution, p. 759, 760. The effect of the second part of Article 31C is that even though a law is in substance not in fusturance of the objects mentioned in Articles 39B and C, and has only a slender connection with those objects, the declaration made by tile legislature would stand in the way of a party challenging it on the ground that it is not for the furtherance of those objects. A power is thus conferred to make a declaration in RCS-PCCCT of any law made in violation of the provisions of Articles 14, 19, and 31 none, and in further, in powering the state legislature to make laws immune from attack on the ground of being violative of Articles 14, 19, and 31, by inserting the requisite declaration. The authority vested with the power to make amendment under Article 368 has in CFFCCT delegated or granted the power of amendment in important respect to a state legislature. The power of amendment being of such vital importance, c. and neither be delegated nor can those vested with the authority TCJ amend, abdicate that power in favor of another body. Article 31C, taken along with the second part, relating to the declaration, departs from the scheme of Article 31A. Because while the protection afforded by Article 31A is to laws may, or specified subject, the immunity granted under Article 31C can be a UCD of even by laws which have not been made for the specified objects. Judicial review is an integral part of the constitutional system. It is open to the authority amending the Constitution to exclude judicial review regarding the validity of an existing statute. It is likewise open to the authority to exclude judicial review regarding the validity of a statute which might be an ad-CD by the legislature in tour in respect of a specified subject. In such an event, judicial review is not excluded for finding whether the statute has been enacted in respect of the specified subject. Both the above types of constitutional amendments are permissible under Article 368. What is not permissible is a third type of constitutional amendment, according to which the amending authority not merely exclude judicial review regarding the validity of a statute, which might be enacted by the legislature in future in respect of a specified BJCT, but also exclude judicial review for finding whether the statute enacted by the legislature is in respect of the subject for which judicial review has been excluded. The position under Article 31C is that though judicial review has been excluded by the authority making the constitutional amendment, the law in respect of which judicial review has been excluded is one yet to be passed by the legislatures. In view of the conclusive nature of the declaration, it would be straining the language of Article 31C to hold that a court can, despite the requisite declaration, go into the question that it docs not give effect to the policy of the state towards securing the principles specified in 58 Suppelami Ort RJ Ports, 1973, Supesca, clauses B or C of Article 39, Therefore, the second part of Article 31C goes beyond the permissible limit of what constitute amendment under Art. Li 368 and strikes at the basic structure of the Constitution. The second part of the article and its invalidity will not affect the validity of the remaining part PPI. 45 to 756. The Constitution 29th Amendment Act does not suffer from any infirmity and as such is valid. Po. 760. The Unterkenntnis that Articles 31B and 31A are linked together, and that only such enactments can be included in the ninth schedule as fall within